Morgan is ill, but we hopefully.
We are live.
All right, thanks, Morgan. Welcome, everyone, to Senate Education. Today is Tuesday, February 6th, 1:10. We're going to spend a little time today and then a little time later in the week to jump back into the home study program. And those of you who follow or don't follow our work, we made a number of different changes to the program last year at the request of the Agency of Education, largely, as they phrased it, simplifying, easier reporting data, all those kinds of things. So I've asked Ms. St. James to come to the committee to take us through as a reminder of what we did. I'm afraid DCF and AOE would like to postpone their testimony until later in the week, perhaps as early as tomorrow, which is what it's going to be. But we do have Ms. Dunlap here, who is the president of Vermont Home Educators, Vermont Home Education Network. Excuse me, Vermont Home Education Network, who will say a few words after we hear from St. James. So, Ms. St. James, the floor is yours. And I'm looking in our folders. Do we have anything in here that?
Yes. Okay. That's St. James Office of Legislative Counsel. You should have a side-by-side of what I'm just going to call, for the sake of this conversation, the old law. And then the new law that you all passed last year.
Great.
And then Morgan has also linked just to the legislature's website, just the clean statute itself, section 166B.
Oh, that's like good. So, Mr. Chair.
Yeah.
Besides revisiting a topic that's for me, is there something that we're pursuing?
Thanks for asking that. I really appreciate it. And Senator Hashim came to me and I think, and I'll let him tell us what might be happening, some of those concerns coming from his district about.
Yeah, so the origin of this comes from one constituent who had concerns about how her grandkids were entered homeschooling, but the parents didn't actually perform any homeschooling. And then there was a concern about neglect, and not because they weren't getting an education, but just neglect in general. And then the grandmother attempted to get DCF and AOE involved, both of whom said, we can't touch this because the law changed last year. So I have no problem with people homeschooling, but I want to make sure that we avoid situations like what I just described.
So we're evaluating the current language to see what may have fallen out.
Yeah, we'll start that way. We'll hear from the school folks, and then later in the week, we're going to hear from DCF and AOE. Both want to weigh in. They're just sort of working, I think, to get their ducks in a row, make sure they're understanding the situation properly, and then we'll come in to talk to us. But we may indeed find things to change. We may not. And I think I agree with Senator Hashim's assessment. I don't disagree with homeschooling. We just want to make sure everybody's catching it.
Thank you. So the side-by-side you have on the left-hand column on every page is going to be the old law. There's no longer it's no longer what we're using, but it is just for the, rather than go through like a marked up copy, it's just what the law looks like before the new law passed. And then the right-hand column is section 166B, the home study program language. This is what you all passed last year. And so this is current law, and I believe that was a July 1, 2023 enactment date. So I've tried to match up the different sections. For the most part, the old statute and the new statute line up nicely. There are a couple sections where they didn't, and you'll see some pieces of law twice, and we'll walk through that when we get there. But the first section is enrollment notice on both sides of the equation here. You'll see that the time period for when notice is due to AOE for intent to enroll a student is a little different. So under the old law, it was enrollments expired on July 1, and so you needed to submit a new notice every March 1st or anytime after March 1st, and then it included certain things, and we'll walk through that. Current law requires a notice of intent to enroll a child in a home study program at least 10 business days prior to commencing the home study, so there's no calendar tie there, it's just 10 days prior to the start. And then the notice has to include the following. So you'll see both subdivision ones contain basic demographic information. There's a little bit of new information required under current law, including just kind of to specify the date and month of the year of birth, not just the month and year of birth. Names and mailing addresses for parents or legal guardians. There's some extra language in the new law about those who are legally authorized to make educational decisions, but and it adds email addresses. And then subsection 3, there was a substantive change here. So the old law required that with this enrollment notice, you had to include for each child enrolled during the preceding year, any assessment of progress required under subsection D of the old law. We'll look at that.
Okay.
What was required under subsection D is not exactly the same as what is in subdivision 3 over on the right-hand side, but it's the same subject matter. So we'll look at them side by side when we get there. But for the purposes of looking at it in the context of what's due to AOE when you're enrolling a student in a home study program, it's an attestation. The academic progress of each child enrolled in a home study program will be assessed at the end of each school year, and that the parent or guardian will maintain the record of such assessments. And then the permitted means of assessment are standardized tests, review of students' progress by a licensed teacher, a parent portfolio, grades from an online academy or school, or evidence of passing a GED. And we'll look at that more closely when we can see that kind of parallel language that was repealed. We're still in what's required as notice to AOE during enrollment. So whether there's documented disability is required. And then subdivision 5 is also a little bit of a substantive change. So subject to some provisions that occur later on, each child being this current old law that I'm talking about, we're on the left-hand column. So the old law required each child being enrolled for the current year to provide AOE a detailed outline or narrative that describes the content to be provided in each subject area of the minimum course of study, including any special services or adaptations, and they did not require methods or materials to be included in that. Current law on the right-hand column, same subdivision 5, just requires an attestation. Each child being enrolled is going to receive the equivalent of at least 175 days of instruction in the minimum course of study. And then the minimum course of study is defined there depending on the age. Subdivision 6 in the old law was repealed in the new law, so families are no longer required to include signatures, names, addresses, etc. of persons who will provide ongoing instruction in each area of the minimum course of study. Subdivision 7, they are still required to provide signatures of all parents, guardians, and those who are legally authorized to make educational decisions. Or the alternative, the parent seeking enrollment may provide an attestation of sole primary educational decision-making authority. So that's subsection A and what's required for enrollment.
And I think maybe this is the section, we'll see as we go on, but well, I guess I'll wait if there are others.
Well, let me jump to the big one.
Okay,
So if you want to look at, well, I'll jump to the big one.
okay.
So if you go to page 6,
6 of the side by side.
yes. Remember, left-hand side, old law.
Yeah.
Right-hand side, current law, you'll see a series of repeals.
Yeah.
And this is the hearing process. So subsection E in the old law allowed the Secretary of Education to hold a hearing before enrolling a student in a home study program if the secretary had information that creates significant doubt about whether a home study program can or will provide a minimum course of study. And
Sorry, can you say that again?
Yep.
So this is before enrollment. It used to be the secretary could hold a hearing.
But- Yep.
No, please go ahead.
only if
Yeah,
the secretary had information
okay,
that created a significant doubt about whether a home study program can or will provide a minimum course of study for the student. So that's the narrow,
and that's E.
that's subsection E, yes,
Okay,
that is no longer
right.
on the books.
And then repeat.
It's been repealed.
Okay,
Subsection F and some subsequent sections deal with hearings after enrollment, and you'll see that those sections have also been repealed. So old law was that if the secretary had information that, and I'm on subsection F on page 6,
Mhm.
if the secretary had information that reasonably could be expected to justify an order of termination under this section, the secretary could call a hearing.
Mhm.
And at the hearing, the secretary needed to establish one or more of the following. The home study program has substantially failed to comply with the requirements of the home study statute. The home study program has substantially failed to provide the student with a minimum course of study. Or the home study program will not provide the student with the minimum course of study. So it's either failed or it will fail.
Mhm.
And then subsection G provided the notice and procedure for that type of a hearing. That's also been repealed. And then the order that would be required after the hearing has also been repealed. So there's no analogous hearing process. There's no analogous way for AOE to challenge enrollment in a home study program under the current law.
So if Senator Hoshi met a constituent who they really concerned may not be getting the education that he or she needs, the AOE doesn't really have the ability to go in there and say, this is a problem.
Under this
Under
statute,
Under
correct?
this statute, okay,
And yes,
okay, thank you.
that's one of the biggest substantive changes.
Yeah.
I would say another substantive change that we kind of have talked about already is on page 1. Subdivision 3. Enrollment used to require the assessment of progress required under subsection D of the old law,
Mhm.
and now current law just requires an attestation of the academic progress. And if we scroll down to page 5
Again, on side by side.
on the side by
Yeah,
side.
yep, progress assessments.
Yep.
Yeah,
So I've lined up what the old subdivision D, talking about progress assessments. That subject lines up with the current subsection or subdivision A3. So I've plunked the language that we just walked through above down so you can see it next to the language that it most matches up to.
Mhm.
So old law required each home study program to annually assess the progress of each student. And the progress had to be assessed in each subject area of the minimum course of study by one or more of the following methods, and we'll talk about those methods. Current law requires an attestation that the academic progress of each child enrolled in home study program will be assessed at the end of each school year and that the parent or guardian will maintain those assessments. So, old law require, the options for those assessments were, a report by a licensed teacher. An AOE would be required to develop a form, for that teacher to provide that assessment. Current law still allows for review of the student's progress by an individual who holds a current Vermont teacher certificate, but that requirement that AOE develop a form has been, it's no longer in the statute. Old law, I'm looking at subdivision 2 and subdivision C. Old law was a report, could be prepared by the student's parents or instructor. Or a teacher advisory service report from a publisher of a commercial curriculum, together with a portfolio of the student's work that includes work samples to demonstrate progress in each subject area and the minimum course of study. Current law, one of the options that matches up to the old option is that a parent or guardian could have a report and portfolio to include a summary of what the student learned and at least 4 samples of student work. So old law, sample and progress in each subject area, the minimum course of study. New law is at least 4 samples of student work and summary of what the student learned. Both old law and current law allowed for assessment to be made using a standardized test. Old law required that test to be approved by the secretary. And then there were some things the secretary needed to take into account when approving those tests. That approval process has been taken, is no longer in statute. Current law provides 2 additional new options for the assessment, and that is 1, grades from an online academy or school, and then 2, evidence of passing GED. And those are the big, let's see. Just looking at the other things to see. Those are the big substantive differences between 166B prior to July 1, 2023 and 166B now.
So what happened? Difference of, secretary? Is it-
No, they came in, you may recall last year, and they, oh, right, it was Dan French at the end.
Yeah.
Was Dan French at the end that, made the recommendations. And I think Heather also weighed in on these. Mostly around streamlining, making sure that we can get data collection more easily. They felt as though some of this stuff wasn't happening and wouldn't happen. I am concerned personally that there isn't some way to, again, go to somebody's district or home and say, hey, we're concerned. We're gonna hear from DCF this week and AOE. I know talked to the House chair about this summer when it came up a little bit. I know they too were in favor of this, but we can always make changes. We need to. Yeah.
Can I ask a question to my colleague, because I
Yeah.
asked at the beginning, so you have some folks in your area who are saying that they're not getting the educational outcomes that they wanted?
Yeah, there was that component, and then there's also just an additional general neglect component, and so the concerned grandparent reached out to both DCF and AOE, both of whom said there's nothing we can do because of this new law.
Okay, because I mean, I'm thinking to myself, isn't that one of the beauties of homeschooling, is that if they don't like something that they're doing, they can change it, so that they can, I guess I'm just confused.
What do you mean?
Well, so if they're feeling like,
Go back one step.
Yeah.
Explain the scenario.
Yeah, it was,
It's
right,
true.
sorry, I should count that.
sorry, I missed it.
Grandparent observed that her grandchildren were being homeschooled by the parents. Grandparent observed a lack of actual homeschooling and neglect or allegations of neglect between the parents and the grandkids, and despite the grandparents' protests to this and her attempts to get to AOE and DCF, they couldn't do anything.
Okay, and that, if I can have a follow on.
Yeah,
that'd be-
please.
Thanks, I guess I'm a little bit confused, because, yeah, we heard testimony last year from the AOE saying that the statute wasn't actually being upheld, they weren't doing the things that are here. And so why have it on the books when they're actually not doing it? So I guess this is a larger question, who polices the police, who is
Yeah.
in charge?
And that's why we're gonna hear from DCF and AOE
Okay.
to hopefully better understand I mean, I know you're not DCF. But based on what we've said around AOE in this, is it accurate that based on this, a complaint could not be, I mean, a complaint could be filed, but it wouldn't be followed through. There isn't the teeth anymore that would actually allow AOE to intervene.
I mean. There's no mechanism in law that would allow AOE to say, no, home study's not appropriate for you, or home study, you're not meeting the requirements of the home study statute.
And I'm sorry, repeat that. So there's nothing in the law that would prevent AOE from going to somebody and say, you're not meeting the statute.
No, there's nothing in law that would allow them to
Would
do
allow
that.
that, right.
That was repealed last
Okay,
year, the
sorry.
hearing process.
Okay.
But the hearing process, remember, was limited, very limited in scope.
Yeah,
It was around minimum course of study and complying with the requirements of the section. So that is not a broad, someone has made a determination that home study is not appropriate for this family. It's the old law was still very limited in the circumstances that AOE could consider or make determinations that the student should not be enrolled in a home study program. Current law provides no opportunity for AOE to weigh in on the minimum course of study or whether the program is complying
Right.
with the statute. DCF and child neglect laws are a whole separate ballgame, and I can't speak to that.
but there's nothing in here that we altered in any way that would impact DCF's ability. You know of.
I think that would be a question for them.
Okay.
It's possible
Mhm.
that in the grand scheme of the universe, right?
Yeah.
It's possible that there is some rule or statute that says if AOE has made a determination that homeschooling, the program, someone is not providing the minimum course of study or has substantially failed to comply with the programs of this requirement, that is some sort of de facto finding in an abuse and neglect case.
Yeah.
I have no idea if that
Yeah.
exists, but this statute, for what it provides AOE authority to do, the hearing option, whether that's before or after enrollment, has been repealed, and there was no mechanism in place. And how that impacts DCF's process would be a question for,
Senator.
I think that, if I remember correctly, the AOE was in support of this. So,
They proposed it, these were their suggestions, and now we're, as sometimes happens, seeing that there might be. Yeah.
So are you teeing up for like a subsection in the miscellaneous?
Miscellaneous.
Make a correction.
Yeah.
Swearing was.
Yeah, that'd be the most logical spot, and we'll hear from, I don't know if we're hearing, have you been in contact with Commissioner Winters, Secretary?
Yeah, I can't say. No, I've been indirectly, I've been on email threads
Okay,
involving the people involved in this. And I did start the process of getting language ready that
beautiful,
to address some of this. So
beautiful,
then we can have that on the table.
nice.
Star.
Gold star.
Yeah.
That's great, great. Anything else from you, Ms. St. James, or questions from Ms. St. James? We have, just by chance, Ms. Dunlap here, who will represents the homeschoolers, and if you don't mind sticking around.
Sure.
That'd be great. Thanks for joining us.
Thank you for submitting these to me.
And before you jump in, Morgan,
Yes.
do you mind checking with Ted to see when they're thinking about coming in? I thought they were gonna try for Wednesday. AOE, yeah,
I will check with them.
thank you. Dunlap,
Hi, I'm Rita Dunlap, and I'm president of Vermont Home Education Methods, and I'm thinking I will just have to rearrange my entire life to be here when they come in, but,
Welcome to our world.
yes, well, it's how it works here.
Yeah.
Where to begin? Yes, the language was put together by AOE and they pushed it. Homeschool, we've been talking about something like this for years, okay? Because the paperwork really doesn't protect children. It doesn't, because I can fake it all. Okay, so handing the paperwork that they spend hours to review just doesn't get us anywhere. And they came up with language, I didn't argue with it, but the hearing process, all right, so one of the reasons why I wanted this to be, and also Secretary French, is that this is like almost instant enrollment. Paperwork is in, you're enrolled. And frankly, we want it that way, because if your child is being bullied in school, it used to take 2 to 3 weeks to get them out of there so they could home study. This way they can almost instantly slide over. Okay, so hearings before enrollment, they went away. And really, hearings before enrollment, and hearings after enrollments were pretty much the same, except the hearing after enrollment was the burden of proof on the hearing before enrollment was on the parent. The burden of proof after enrollment is on the agency. They have to prove that there's neglect, and really the neglect is, can this parent provide a minimum course of study, or are they refusing to? Can they, or will they, are they able? That was what the hearing was about, and that's it. So, I'm also concerned about a hearing after enrollment being in the agency. The fact of the matter is the agency doesn't want to do them. They cost, 20 years ago, I was told they cost $20,000 to conduct one of these hearings. So they are rarely called. And when they are, there's usually something serious going on. But the Agency of Education is not, their mandate is not child protection. That's DCF. So what I have been telling homeschoolers, and they're slowly getting the idea, we know we have to do this and keep it on file at home. They're all out there on the message boards. I no longer have to say it, they're saying it. You have to do an assessment and keep it on file. So they're telling each other this. But where am I going with this? Yes.
Can you, so they have to do this, so they're saying to each other,
Oh, yeah, the
we
law.
have to do an assessment and we have to keep it on file.
Yes, that's.
Who would do the assessment and when would it be?
Well, it's the same as before. The parent can do a parent portfolio and a parent report, or you can do standardized testing, or you can hire a teacher to come and do an assessment. You can do GED. I think I'm covered. They still have to do those
Once a year.
end of school year, and keep it on file at home. And that reminded me that, so what I'm telling
But
you.
just to follow up on you, if I may, so if, for example, at the end of the school year, if you're not doing the GED because you're not of a certain age, what might you,
You have to do one of the others.
a portfolio
Yes.
showing the academic work, representing the academic work throughout the year, and that the child achieved
And
certain things.
in the old statute, I can't, as many times as I read these statutes, I just still can't remember all the little details. The assessment is to show progress on an education. Not that did they reach an A level, if they didn't, can't homeschool. No, is the child progressing through their education? It's K-12, same thing in the public school. Is the child progressing? That's the measure they're using. And what I've been telling parents, I said, listen, don't jump for joy just because you do this, you file it on home. I said, if you slough off and you don't do this, guess who you're going to be facing next? If someone figures out there's educational neglect going on in your home, DCF. DCF has the, and I'm not a lawyer, okay, but I've read their statutes. Educational neglect is in the bailiwick. It's their job to go after educational neglect, should they find it. Now, I was told when we were talking about this statute or a year before we actually did this, I talked to someone high up in the DCF and I asked them what they did. And they said, we don't usually start at educational neglect. We start, neglect, abuse. There's some serious stuff going on. And then there can be an educational neglect component of that. And so I'm surprised. Well, no, I'm not. Honestly, DCF is overwhelmed, and you all probably know that way better than I do. Okay. hi, my grandkids aren't being taught math and reading and writing is probably not high up. Now, should it be in a perfect world? Yes. There should be some mechanism, and to me, the mechanism is now in DCF, and we don't have to change the laws because the mechanism has already always been there. It's a family court and it's a CHINS proceeding. Now, is that process working well? I don't know.
But I think, and I'm sorry, I think what we'd like to be able to do is, and I appreciate you recognizing that DCF does have a real load.
Yeah.
And we don't want the situation to wait, so we may, alter these in order to get in there faster, have AOE involved, and we'll find out, if their thoughts on it as well.
Yeah, and I very much want to hear that, and I would not be opposed. Now, this is just me speaking. I'd have to ask homeschoolers. I won't be targeted other anything. I wouldn't be opposed to hearings after enrollments being a part of basically being put back. But the statute, as the new statute as it is, I would like to see remain the same. Okay, because then this grandmother could ask, and the agency could call a hearing, and lawyers get involved, and I'm sure there's evidence based in all of this, but it would, because, I protect homeschooling and parents' right to do that, okay? But I also am not interested in hiding children being neglected. Because I can tell you over the years, I've talked to some families and I said, look, you all need to put your kids back in the public schools because you're gonna hurt homeschooling, never mind you're hurting your children, put them back. And typically these families were such, they just needed someone to tell them what to do and they do, and it's rare, I've had to do it like a few times, but.
Thank you for testifying. It's really helpful. I agree, and I think I would also support having the hearings after enrollment provision put back in. Initially, I was leaning towards, looking at what initially has to be filed with AOE, but your point is well taken. So, yeah, I mean, I would support putting back in hearings after enrollment, and I understand it's something that's rare and pertains to very serious situations. But I do think that in the rare occasion when those serious situations do happen, there should be that mechanism.
I mean,
And would you mind just reminding us what that looks like, the hearings after enrollment?
the hearings after enrollment, the Agency of Education.
Yep.
Has the burden of proof on them, and that, I know that, and I'm parroting that because that's what Barbara Crippen, the AOE lawyer from years ago, she was just, stellar with the details of the statute. The burden of proof is on the agency, so families would have filed their paperwork. And in this case, they have an attestation, we promise to do this. Now, they have to sign something, it's almost like an affidavit, but not quite. They signed something that said they were going to do this, so DCF, I would think, could indeed take that piece of paper they signed and say, you said you do this, where are those tests? And so that, to me, that, like, schoolers do your jobs, but, one other thing is, I know the agency over the years has found this to be very stressful to do these hearings, and it takes up a lot of time. And if that grandmother had come and said, my daughter and son-in-law, they're not feeding the kids right, and they go into, and they're skinny as all get out, and things like that. Would we put a mechanism in the health department for them to make a determination whether dietary or nutritional neglect was taking place? No, we would send them to DCF. That's their job. If the child is being in some way harmed, that's a DCF thing. And so I'd be very interested to hear what they all have to say, but I have heard what they have said for 25 years. And I'm too surprised about some of it because these agencies, especially DCF, is just overwhelmed as well. There's societal problems going on. Our bigger questions that I don't know that committees and legislative laws can solve. I don't know, but those really need to be addressed, and I don't know how to do that. Except up one-on-one with me in person. So anyway,
How many homeschool children are there?
last I knew there were 3,500 a year. The numbers, I don't know that they've really gone up. I haven't heard because I don't bug them too often because they're just good to get that number. But yeah,
Senator Williams?
No, I think it's not just isolated to education, it's, you know, we put so many bills in, how can any agency provide the oversight on everything they need to?
Hard.
That's why I say when a bill passes, they should budget the funding to provide that oversight, to provide the people power to do it. And, you know, we live with all these bills that we pass, and it ends up being a new position on everybody. So, I don't know how you slow it down, unless you cut, you know, we're up to, I think, 1,200 bills right now in this biennium. And fortunately, not many of them have passed, but every time they do, it just adds requirements we can't take care of. In my opinion.
So Senator Archie, what are you thinking might be the best solution from your end? Any thoughts?
Yeah, I mean,
Because if we get this out on the table a little bit, maybe AOE and DCF can hear and then they can come in and actually say, okay, this works for us.
yeah, I mean, my knowledge primarily came from the constituent who had interactions with DCF, so I don't wanna inadvertently make it seem like I had a direct conversation with DCF. Yes, just want to put that. No, I think, you know, like I mentioned earlier, I think having a hearing after enrollment, having that as a tool, I think it makes sense. You know, I get that neglect or, you know, malnutrition is in one area, but, you know, if it's homeschooling, it's going to be tied to the education component as well. So, yeah.
Great.
I'm just thinking outside the box, so to speak. I'm just wondering, is there an alternative to a hearing? Could it be something maybe less? Yeah,
They are very ominous for.
yeah, could it be like an assessment or an interview or? I don't know,
Okay,
I'm just
yeah, no,
wondering
no,
if this is like a
yeah,
binary
yeah.
choice or.
And that might be, you know, I've definitely asked that at the agency, but I will tell you, with the language that is here on the hearings after enrollments. That was really hammered out in 1986 and the whole issue of parents being able to do this and everything. And the goal was that this hearing process must protect the right of the parent to educate their own child. And during this process, that right due process was given to that family, that those parents, that their rights, yes, we're respecting your rights, but if you are not fulfilling your rights, then the state can step in. So any process you come up with that I would be able to support would have to would have to be, you have a right to do this, and this hearing's determine if you have a right to continue, kind of thing. I guess that's a really blunt way of putting it. And that's what that old hearing process did. So I would, right now, since it's, you know, totally new today to me, I would support the old language for hearings after enrollments. If we go and change it, I'd have to rework that and see, because that's where I'm coming from, is, you know, to me, the family, the parents, they need to have this space where they can be protected and encouraged to do their duty, as far as I think. It's a duty, it's not something that you just play out in the woods with, although you can learn in the woods, that, but it's a duty, and so they start with that right and that premise. But understand, the state also has a duty. And I call it parental rights, parent, state's interest, and the state has an interest in this, and that's why there's a hearing. Sometimes helps with, is there something lesser than that? Yeah, it would be interesting to discuss.
I don't know if I want to reinvent the wheel.
Yeah,
And
well, we're all familiar with this process, and if they don't, it's rare, it's probably not a big deal, but would they call it in this instance? I don't know, they have that person would have to convince the agency, here's the evidence that, because the burden of proof would be on the agency to say there's some neglect here and we want to stop this and all. So I get lawyers and all that involved.
Okay, but this one is at the L24. This is, you've got a piece that we've heard of it. Do you have a question?
No, just a comment. So certainly we look forward to AOE's comment. And maybe they could propose some language. Make it simple. Take testimony.
Anything else?
What I would normally talk about, I'm not going to talk about because this is important and great. There's just little things with the statute and how they're implementing. it. I'm not sure they're following the statute. Little things.
Anything else from Ms. Dunlap? Anything else from Ms. St. James? Retta, thanks a million.
Thank you.
Appreciate you being here.
And just keep an eye on the agenda for tomorrow.
Beautiful, great idea.
It was
I think it might be
nice
Friday.
drive.
Good, I'm glad. Where'd you come from?
Woodbury.
Oh, yeah, that's a
Woodbury. Okay, thank
Yeah.
you.
Senators, in your packet is the letter from the United States Department of Education. You know, some of us may have received calls last week from the press about this. This was sent to Secretary Boucher. Don't have it. Okay, let's think the way. It's two piles. There's one in your file. There's this, and there's also. Yeah, there's just like this little tree at the top. Marilyn, do you have it? Yes, sir. So, when I asked Ms. St. James, left, maybe not the best person to sort of take us through it, but what I thought, we have the Secretary of Education coming in about 5 minutes. So if you want to take some time, review it yourselves, we're gonna have the Secretary in to respond to it. Take us through it, outline what the agency's response is to it. And so we should, hey, Morgan, is the secretary coming in person?
I believe they are zooming. I can double check on that.
Okay, why don't you take us off for a minute? Well, and then when she's ready,